Hello again, everyone, and welcome to Marquette University Law School, the virtual Lubar Center. I'm Mike Goucher, and today we are releasing the third part of our national survey of public attitudes toward the U.S. Supreme Court. Joining us to talk about the results is the poll's director, Professor Charles Franklin. And Charles, let's talk about what we've been looking at the last couple of days and what we'll be looking at today.
Well, this is the second annual survey that we've done of the U.S. Supreme Court and attitudes towards it. This is a national survey. We're in the field September 8th through the 15th. So we've finished the interviews about 3 days before Justice Ginsburg died, and people should see the results in that light of when we were doing the interviews. We talked to 1,523 adults nationwide. That has a margin of error of plus or minus 3.3 percentage points. And occasionally we talk about likely voters, and that has a sample size of 1,357 respondents, a margin of error of plus or minus 3.6 percentage points, though most of the results we'll be talking about today are based on the adult population sample of the 50 states.
So we've been looking at the political importance of Supreme Court appointments. We've been talking about the legitimacy of the U.S. Supreme Court. Today we're talking about cases. Give us just a brief preview of what we're going to be looking at.
Right. We're going to start with talking about how the public believes justices do decide cases and how do they think they should decide cases. And then we'll turn to some recent decisions from this past year, and we'll look ahead to some issues and cases that either are on the court's docket coming up or seem likely to be part of court cases in the foreseeable future.
So let's begin with the question that we asked voters in this country. What motivates justices in their decision making? Is it the law or is it politics?
Yeah. We find in this survey that 62% of respondents say that justices are motivated primarily by the law. 37% think they are motivated primarily by politics. In a heated debate like we're going through over the next appointment to the court, it would be easy to emphasize the political nature of appointments and the political nature of the judiciary. But I think what we see with this result, and it was very similar a year ago as well, is that for the most part, the public does see judges, justices of the court especially, as motivated by legal issues, but a minority see politics as an important motivation.
Does that vary according to the way you identify politically?
Well, surprisingly, not very much. Across partisan divisions, among Republicans, 39% say mainly politics, 60% say the law. Independents, 35 mainly politics, 65 the law. And among Democrats, 39 politics, 61 the law. That's really remarkably little partisan difference on this question, especially when you consider how sharp partisan divisions are on other elements of the court and nominations and cases.
And let's spend just a couple of moments on attitudes according to your ideology, your self-described ideology.
Here again, we don't see much difference in how liberals and conservatives see the motivations of justices. It's about 35 to 40% of every ideological group that say politics is the main driver of decisions, but it's over 60% in all 5 ideological groups that say primarily the law. I suppose one could say, why is it only 60% and not 90% of every group that say it's primarily the law? But I think on balance, this is pretty telling. And it just so happens that both those who are very conservative and those who are very liberal split exactly the same way. 40% emphasizing politics, but a majority, 60% of both groups emphasizing the law.
And it's probably not surprising, Charles, but those who more strongly disapprove of the court tend to believe that politics is ruling the day.
That's right. And this is where we start to see actual differences. If they're not differences by party or ideology, then who is it that, thinks the court is heavily political? And there we see that those who disapprove of the court, a solid majority, 56%, say decisions are primarily political. Only 44% say they're primarily based on the law.
I'm sorry, go ahead.
While those who approve of the job the court is doing flip that, 28% political, 72% motivated by the law. So, whether it's perceptions of political basis that leads people to disapprove, or the fact that people have a negative view of the court, and that leads them to believe their decisions must be political, I can't answer that question, but this divide is quite striking.
And how much confidence you have in the court tends to have a big impact on how people view the justice's motivations, correct?
Again, you would not be surprised to say that those who are trusting of the court, who have high levels of confidence in the court, overwhelmingly say decisions are motivated by the law. 79% the law, 21% political among those with high confidence. But as you come down to those with just some confidence in the court, 55% say the law, 44% say political. And finally, those with little or no confidence in the court, only 40% believe they're driven by those decisions are driven by the law. 60% say it's motivated by politics. So I think you see political cynicism or political distrust as an important element here that makes people see the court in a more political role. For some people, those who lack confidence in the court, lack approval of the court, but the opposite, a court driven more by the law among those who retain high confidence in the court.
Charles, we asked people how they think the justices should interpret the law. We gave them 3 options. Why don't you walk us through those options and then tell us what people thought about that?
Right. Here we are trying in a context of a limited survey question to touch on 3 major approaches to approaching and interpreting law or legal decisions that are prominent. One is textualism, the idea that the written words of the law should drive the decision. One, originalism, that the commonly understood meaning of the law at the time it was passed should be the predominant consideration. And finally, legal realism, or an evolving constitutional approach, the idea that the law should be interpreted as it applies to current circumstances, and that either the text or the original meaning is not the central focus. So, with apologies to my legal scholar friends and neighbors who might say this is an inadequate portrayal of immense subtlety, that's where we ask people, should the justices read the text of the law as written? 31% say that should be the basis of decision. 23% say that the meaning at the time it was written should dominate. And 45% say the law should be interpreted as it applies to current circumstances.
And do the responses, I would imagine they might, do they vary according to party ID and according to ideology?
And here I think it's an interesting finding, because a moment ago we saw some things don't vary with party or ideology. But here, on the question of how should the judges make decisions, we see striking differences that line up pretty well with conventional understandings in the legal community and in the political community about what goes with what. So here the public sees that in line with more Washington kind of conversation. Among Republicans, there's much more emphasis on the text. 46% say that. and less on the law as it applies to current circumstances, only 31%. Originalism gets about 20% from every group, so I'm going to skip that. But then when we move to independence, 29% emphasize the text, 47% say current applications, current circumstances. And finally, for Democrats, 21% emphasize the text, 56% emphasize application to current circumstances. And as I said, the originalist argument is about equally supported across all three groups, just varying from 21 to 23%. When we go to ideology, the differences are even more striking. I'm just going to give it to you by ideology. The percent that say the text as written should dominate, 56% of very conservative people pick that as the way judges should decide. 43% pick it among conservatives, then 28% among moderates, 19% of liberals, and just 13% of very liberal. So a really striking range there. If we go to the other end, apply the law to current circumstances, the pattern's almost perfectly reversed. Among very conservative respondents, 19% say interpret now for current circumstances. That goes up to 33% with just conservative folks, 47% for moderates, and up to 63% with liberals and 70% for very liberal people. And again, the originalist interpretation varies a little bit more, from 16% to 24% across these groups. So I think it's rather striking. And in some of our earlier conversations, we've talked about how the public sometimes has a pretty limited understanding of the court, how the justices are not household names, for example, or details of the court's powers are not universally known. But here I think we see a case where the arguments between textualism or originalism on the one hand and an evolving meaning fit to the current circumstances really has penetrated through the public in both partisan and ideological groups.
And continuing this theme, Charles, we see this same strong alignment between party ID and ideology when we talk about how the U.S. Constitution should be interpreted.
So here we're shifting specifically to constitutional interpretation, and there originalism is sort of one side of this, and an evolving document with contemporary meaning is the other side. What we find again is that 2/3 I'm sorry, I said that wrong. 69% of Republicans say the Constitution should be interpreted by its original meaning. 31% say it should change over time. And those numbers are almost exactly reversed among Democrats, where 31% favor the original meaning, 67% something that evolves. And independents lean towards an evolving document. 40% say original interpretation, 58% say an evolving meaning. And we see a very similar pattern by ideology that ranges from 84% originalist with very conservative folks, and then steadily falls to just 16% of very liberal folks that pick the originalist interpretation. So again, those notions of constitutional interpretation have also reached the mass public.
Charles, we're going to spend some time talking about recent decisions by the court and potential cases that could come before the court. Before we walk through some specific cases, let's provide a bit of explanation for what we're doing here. You'll hear cases called by name, but obviously there's so much to each one of these cases. We have to make them succinct enough to ask about in a poll. So I'll let you explain exactly what we tried to accomplish here.
That's right. We are asking people, a national sample of non-lawyers mostly, what they think about cases which are very complicated. Let's face the fact that a decision might run to hundreds of pages in some of these cases. We certainly can't adequately cover all of the subtleties of the cases or even all of the major issues. Some of these are simply too complicated and too technical to do that. It's also fair to say that if you read about these cases in the newspaper on the day after they're decided, that those news accounts are also very simplified in comparison to reading the briefs in the case, reading the decision in the case. So that's a confession that our questions are necessarily simplifications of the details of the case. And, we're always representing only one aspect of the case, though, of course, we're trying to capture the kinds of issues that are featured in news coverage of the cases, and therefore the kinds of issues that the public might be more familiar with rather than the more esoteric legal issues that may figure in the footnotes of a justice's opinion, but rarely make it into the news coverage of a case.
So let's begin with recent decisions and something called Bostock versus Clayton County, Georgia. This is essentially an employment discrimination case. Why don't you give us kind of the nuts and bolts of what we're talking about and see how people responded to the decision that the court made?
This was a question of whether bans on sex discrimination should be applied to issues of sexual orientation and transgender individuals. One side of the argument said that when the law was written in the 1960s, the authors of the law had no idea that these would be applications for it. Others argued that the text of the law says sex discrimination and that sex is an inherent part of these cases. So that was the issue that ultimately led the court to rule that Title VII, the law, applies to cases of sex discrimination on the basis of orientation or transgender identity. What we found is that the public is quite approving of this decision. 62% favored the decision to extend discrimination protections, 26% opposed. And here we'll mention, as with each case, 11% said they didn't have an opinion. You'll see some variation in that percent without an opinion, and that's a reflection, at least, of how salient the issue was and perhaps how understandable the legal issues are.
Next case is Espinoza versus Montana Department of Revenue. Again, this is a case that involved an issue of public money being used for private religious schools, not just private schools, but private religious schools.
Yes, again, a little bit of a complicated question that goes back to laws in the 1800s that denied public funding to religious schools with a particular focus on banning funding for Catholic religious schools. In this case, the issue was Montana had a fund for private schools, but because it had a ban on funding religious schools, that funding for private schools was not available to children who attended religious private schools. So the question was, can you ban that funding for religious schools in this case or not? In this case, the court ruled that that ban could not stand and that it was a violation of the First Amendment to prohibit this funding specifically to religious organizations when similar private organizations were funded. Okay, like I said, a little bit of a complicated case. But what we found was that 51% approved the decision to extend funding to these schools, 32% opposed it, and now 15% didn't have an opinion on this issue.
The Department of Homeland Security versus the Regents of the University of California. This, I guess, in shorthand would be called the Daca Case. And how did people feel about what the court decided in this case?
Here, the Trump administration had attempted to end the DACA program, and the case was roughly, did they have the authority and did they go about it in the right way? And I'm not going to go into those details, but the gist of it was that the court struck down the administration's attempt to end the DACA program in the way they did it, though it left open the question of what happens in the future. On this question, 50% agreed with the ruling to strike down the Trump administration's attempt to end the DACA program. 35% disagreed with the ruling. And again, 14%, a kind of sizable number, said they didn't know enough to have an opinion about this.
Case, Little Sister of the Poor, Saints Peter and Paul versus Pennsylvania. And this, again, is sort of a healthcare case that involved contraception coverage.
This is one case in a line of cases that go to the question of how much the Affordable Care Act, or Obamacare, can require private institutions or religious institutions to provide specifically contraceptive coverage as part of their employee health plans. The Trump administration had acted to allow private institutions, including both religious and moral reasons, to not provide contraceptive coverage if they had objections to that. And the court ruled that in this case, the Trump administration could allow that exemption to religious and private organizations. On this case, though, 34% agreed with allowing an exemption for coverage, but 51% opposed this decision. So this is an example of a majority disagreeing with the court's action, and 13% lacked an opinion on this case.
Next case, Charles, June Medical Services LLC versus Russo. This, I guess you could say, was one of the court's major decisions dealing with the abortion issue.
It was, and this one dealt with admitting privileges and regulations in Louisiana about abortion service providers. The court struck down those restrictions in the Louisiana law. 45% agreed with that decision, 35% opposed, and 18% said they didn't have an opinion. Abortion issues, of course, have been before the court for 40 years now and keep coming back. But in this case, the court sided with existing rulings, a previous very similar case, and the public, for the large part, agreed with that decision, though 45% is less than a majority.
Another recent decision, Mcgirt versus Oklahoma, and this is I guess I would call it sort of a case that involved native lands issues. Who was entitled to lands that Native Americans believe they're entitled to?
Yeah, this is a complicated case, and what I said at the beginning about not doing full justice to the details certainly applies here. But it was a striking case, and it was one that the court had a hard time deciding about. They had heard arguments in this case several times before finally reaching a decision. And it's a fairly limited decision that says a particular type of criminal law does not apply on Indian lands, in this case, lands that the Creek Indians received as reservation land back in the 1800s. And so the question is that land still covered by the treaties that were signed with the Creek Indians? And if that is true, then there are implications for this criminal case, which really is the basis of the court case, but is not the interesting part here so much as the question of what are existing treaties with Native Americans and how do those apply today? The court held that because the Congress has never explicitly changed the treaties with the Indian nation, that the nation retains the control over these lands, which include a large part of eastern Oklahoma, including part of the city of Tulsa, and that for the purposes of this criminal law that was part of the case, that's still Indian land. Now, the court decision itself is clear to say we don't know how broad-reaching this decision is. In any case, it involves this question of when the government signs a treaty and never changes it explicitly, is that treaty still in effect? And the court ruled that it is. And so that was the gist of this decision. 27% on this one said they didn't have an opinion. It's a difficult decision. It's not one that became common coverage and lots of public attention. So a lot of people don't have an opinion about it. 47% favored the ruling upholding the treaty obligations. 25% opposed it. It's unclear whether this will become the basis for a continuing set of cases involving the rights of Native peoples. But it certainly is one that's interesting, and its historical focus is interesting as well.
Finally, Charles, on recent cases, we should point out that the court did not rule on affirmative action cases in 2019, but they have ruled in the past on some of these cases. And so we did include a question about affirmative action and past rulings. Walk us through those results.
Yes, without naming specific cases in our question, we simply asked whether the court's previous rulings that race could be used as one element in a decision about admissions to colleges, and that did you favor or oppose that court ruling. 17% favor that use of race in admissions. 73% were opposed, 10% said they didn't know. This also is little changed from a year ago. One of the reasons we asked about this is that there are cases in the lower courts that may make their way to the Supreme Court at some point, but also this rests on previous decisions which have been controversial and widely covered at their time. It's an area in which public opinion has largely disagreed with the court for some time, and still does in our survey.
So let's talk for our remaining time about potential future cases. We emphasize that word, potential future cases. And we'll begin with the one that is being talked about a lot right now in light of Justice Ginsburg's death, and that is Roe versus Wade. What did we ask our respondents, and what did they tell us?
Yes, after being at the center of political and legal debate since the 1970s, what we found is that 32% would favor striking down Roe versus Wade, 55% would oppose striking it down, and 12% say they don't have an opinion. This is, of course, an issue that's very much of contemporary interest and is likely to be part of the confirmation debate this year as well.
And a case that is not a potential case, well, I guess it is for the moment, but it's not a hypothetical case. You have the Affordable Care Act, the constitutionality of that is being challenged. The Supreme Court says it'll hear oral arguments. It's after Election Day when that is scheduled. How did people feel about that as a case and a potential ruling by the court?
Yeah, there are a pair of cases the court has agreed to hear on this. The way we ask the question is, would you favor the court striking down the Affordable Care Act? 36% would favor that. 52% would oppose it, and 11% say they don't know. I would add that in reality, the court might strike down the entire act, might strike down only part of it, or might uphold the entire thing. We did not present respondents with that full range of options. It was simply a little too complicated for us to get into in a survey question.
Any potential Second Amendment cases, Charles, to keep an eye on? I think we asked about one in this survey.
Yes, one of the striking things was that the court seemed to be ready to hear a number of Second Amendment cases in this last year, but then ended up not deciding any of them, not taking most of them, and ultimately declaring one that they looked to take as moot, having already been decided because the law had been changed. So it seems likely that Second Amendment cases are going to come before the court at some time in the future. So the one we focused on is currently being debated and decided in at least a couple of federal circuit courts of appeal. And this deals with high capacity gun magazines, high capacity number of bullets, and the regulation of those high capacity magazines. And we asked the question in terms of Second Amendment, does the Second Amendment prohibit restrictions on high capacity magazines? 37% would favor a ruling that strikes a regulation down as violating the Second Amendment. 50% would oppose striking down such a regulation, and 11% say they don't know.
There's also a potential employment discrimination case that we're trying to watch.
Here, there are a variety of cases that go to the issue of how much private employers, but especially religious organizations, should be free of discrimination laws with respect to employees who are involved in the transmission of religious beliefs in some way. And so as these cases have developed, we tried to ask a relatively generic question about whether in general religious organizations should be exempt from anti-discrimination laws when it comes to these employees that provide some form of religious instruction or exhibiting religious values as part of their work. 42% would favor a ruling that says the First Amendment allows religious organizations to be exempt from these discrimination laws. But 43% oppose, so a very even split here. And this may be another example of an issue which the public is less familiar with, but one that the courts are beginning to deal with and have dealt with in the past. 14% say they don't know about this issue.
Another possible case involves the authority to regulate, for a lack of a simpler way of putting it.
The way in which the federal government regulates across every area of society is one that's become the subject of several cases. And again, we're looking in general at this. But one of the key questions is, how specific does Congress need to be when it gives authority to a regulatory agency, to create rules in an area? And some sides of the argument say, if Congress isn't explicitly giving the authority, the agency should be pretty limited in what it can write rules about. So we asked if people would favor a ruling that says federal agencies may not write regulations unless the substance of the regulation is clearly defined by Congress. What we found is 53% would favor that kind of limit on regulatory agencies. Just 19% would oppose it. But here again, in a technical area that's not before the public regularly, fully 27% say they don't have an opinion about this issue. It's not that prominent, but it is an issue that could affect the structure of the federal regulatory state, and therefore it's of real interest from a policy perspective.
Charles, what about the laws that could make it harder for supporters of one political party to vote?
Yes, again, this is not modeled on a single case, but if you think of the arguments in some of the redistricting cases, some of the voter photo ID and other kinds of cases, an element of that is whether laws that as a practical matter make it harder for one party to vote but not the other. Should those laws be declared unconstitutional? In our case, 48% favor making those laws unconstitutional. 21% would oppose it. And again, not a household issue. 21% say they don't know about this.
And then there is another case that is set for argument this fall. It's called Fulton versus the City of Philadelphia. This involves foster kids, same-sex parents. Tell us a little bit about the case and what we asked our respondents to weigh in on.
The part of this case, and again, it's a complicated case that we focused on, is whether a religious social service organization that, because of their religious beliefs, will not certify same-sex parents for foster parenting, can the city exclude them from the public program for foster care? Or does the First Amendment protect their religious views in this area, and therefore they can't be blocked from being part of the public program? 40% favor excluding an organization from this public program under these circumstances. 44% would oppose excluding this religious organization, and 15% don't have an opinion. So again, a pretty even split. I think if you look back at some of the cases we've talked about, on some of the cases, there's a pretty even divide, and that has happened partly in cases that may be complicated, but also partly in cases where it's not clear which side a case falls on in terms of people's partisanship, ideology, religious beliefs, and so on. Others are a bit more lopsided, and we saw that as well. And finally, there's a variety here of cases that the public agrees with the court in its decisions, and another set of cases where they disagree. So we started talking about what motivates judges' decisions. Yesterday, we saw that a large percentage, 66%, approve of the job the court is doing. And I think the findings today show that that large approval of the court is not based on universal agreement with its decisions, but in fact, we have some divide over decisions the court reached in the last year, and yet we still have that 2 out of 3 approval rating for the court.
To summarize, Charles, I think would it not be safe to say that the court, despite our very partisan political environment, what some people see as a growing toxicity in politics today, the court has withstood that at least fairly well compared to most of this country's major institutions?
I think that's largely true, but it's not impervious and it's not necessarily permanent. What we see looking across all of our results is a substantial confidence in the court, institutionally, substantial trust in the court, but that's mitigated by a lack of familiarity with the details about the court. People are not familiar with most of the justices. They're not familiar with most of the cases. After all, most of us are not lawyers and are not following decisions on a daily basis. But that said, people are pretty positive in their beliefs about how justices reach decisions. They're more divided in how they think judges should reach decisions. And as we just saw in going through these cases, people differ quite a bit on what outcomes they prefer. But despite all of that, the court retains a legitimacy, an approval, and a confidence level that helps it weather these storms. We also found that the public, for the most part, sees the court as a moderate or right tilting, but not strongly conservative organization or institution. 50% identified the courts as a moderate court, with another 30% saying it's a conservative court, but that's a center-right perception of the court. This also probably helps the court that it is not seen in starkly ideological terms. However, as we've seen with appointment battles in the past and seem likely to see again, the politicization of appointments, the politicization of the view of the court, and a willingness to change the structure of the court, something else we saw in our survey. Those are things that are challenges to the institution and its long-term legitimacy, even as it comes into these issues with a surprisingly strong base among the American public.
And as we pointed out, Charles, again, we were finishing up this survey 3 days before the death of Justice Ginsburg, and a lot will play out in the next, month or month and a half. And I think that's one of the big questions. What will the political battle over what comes next do to some of these baseline numbers that we've seen in this poll?
I think this is a very important question. And I think if we take all of our results together, I would say that on some of the institutional questions, it may not change those. But in terms of the perception of the way the court decides and some of the issues, and especially the tactics of dealing with court appointments, those things seem likely to be extremely dynamic, and the leadership of the parties will play a big role in how people see the role of appointments and institutional change as we go into the next year, and for that matter, the next decade.
Before we go, again, for people who want to look at the entire survey, all of the questions, the methodology, everything that they would want to see, they can just go to our website and everything will be there?
They can go to law.marquette.edu/poll, P-O-L-L, and there you'll see in reverse order the 4 releases that we've done based on this survey. At the top of the page, you'll see a little button for results and data. And if you click there, you'll see the full-blown technical details of the survey. And with this release, this is our last release based on this survey. We will be posting there the complete questionnaire, all of the responses, crosstabs for those questions, as well as the methodology statement of exactly how we did the survey.
Charles Franklin, the director of the Marquette Law School poll. Always a pleasure to speak with you. Thanks for walking us through the results again today. And we appreciate everybody who joined us either just for today or joined us for all 3 of the presentations. Thanks so much for being with us. Mike Goucher from Marquette University Law School. Have a good day.